Hello.
Hi, Caroline and John. See you
Hi.
guys. John,
I'm Manal. उसको मंजेश को बोलना काफी बना दो.
everyone's starting to sort of come on in. We were just saying, Margaret's looking very shrouded in darkness because she's had a power cut. So she's coming in candlelight, phone, etc. So dedication to the
Power
cause.
Where?
Monganui, Northland.
Okay.
A few hours north of Auckland. It's really pretty and the best fish and chips in the whole country.
The best, which I had, planned on tonight. So it was bread and butter.
Oh, bugger.
Oh, Margaret, I don't think we're feeling sorry for you.
Yeah. You've got nude lighting as well.
I had nude lighting.
Yeah.
Mm.
Actually, I quite
all
like it.
candlelit. All candlelit.
It's very pretty. See, Isaac's joining us. Is he sitting in chambers or at home? Hi, Isaac. Get a look at your chambers mate sitting in darkness up in Monganui.
I can't see Isaac.
No, he's down the bottom of the screen, but he's got his camera and his microphone off. We see you there, Isaac, though. We know you're there.
I'm so pleased.
Oh, and thank you for the champagne the other night at your chambers. We did enjoy that.
This is that's more our style, Sarah. So you'll get used to this group. It's not all just fish and chips and candlelight. We tend to be a bit more of champagne.
Listen, I love fish and chips.
Well, it does help that Margaret and Isaac's, one of their chambers mates, has his own winery. We're just saying.
Oh yes, that was good.
It was good. It was very enjoyable. Although the alcohol-free stuff,
no, that's a bit pointless.
well, it tasted like cordial, but not really my thing. Never mind. Hi, Winnie. He's waving.
Sorry, did I scowl when you said alcohol-free alcohol?
Yeah, you did. I could see the furrow
It was
around.
so obvious. Should have turned my camera off.
You need to work on your poker face, Winnie.
It's not when it comes to wine.
On. But keep वो आए होने में गलत ना feed करते.
We'll give everyone a couple more minutes, shall we, William, and then we'll kick off.
Yeah.
ईमेल में भी ड्राइव कर लो सारे.
Yeah.
ईमेल भी चढ़ा ले.
Yep.
ईमेल
I think
भी
I'm
करना कि नहीं. आप check
I'll be
कर
doing
लेना
that.
एक बारी.
And if Margaret, you suddenly light up in the middle of it, we know that you've got power back on.
Actually, I sincerely hope I don't, because then you'll see I'm not. Yeah, it's a better look in the half light.
The only thing we worry about nowadays is getting everything charged, isn't it? That's honestly.
Yes.
The electricity matters so much just to get us all charged and get our phones and our laptops and whatever.
Yeah.
A bit of light, that's okay,
I keep one of those little battery packs that you can slap onto the back for emergency charging, and I take it everywhere because my phone's now getting so old. Yeah, if it wasn't for
That's
that.
the only reason I'm here, because my husband had it, Liverpool supporter. He's got a Liverpool one, and it was charged because my phone was not.
Ah, oh, that's handy.
Lydia, at times like this, I use wine to get charged.
Well, when you live in South Africa, you learn to keep things charged all the time because we have load shedding.
I'm sure. Well, look, why don't we kick off, William? Are you happy for me to?
Let's get ourselves underway.
Let's start. Well, welcome everyone to
This meeting is being recorded.
Now I'll start speaking. Welcome everyone to this AP hour for September. I'm your substitute player this evening. Our president, Kyun Wong, is, I think, working her way back from the meeting in Seattle. So unfortunately, you're stuck with me as the person leading the session. So this evening, as you are well aware, we've signed up for a session on the cross-jurisdictional comparison on the preservation, use or destruction of embryos in a separation or divorce situation. And thanks to William for the brilliantly putting his hand up to do this evening when he'd mentioned to me about this case that had come out of Australia, and I happened to say, well, that would make a fantastic AP hour. And before he knew it, he was moderating a session. We've got a stellar panel this evening, and may I add that we're very lucky actually that one of our panel members was able to join us, Margaret KC, who you will see there in candlelight, is in northern New Zealand in a really beautiful beach settlement called Monganui, but we're having some fairly wild spring weather in New Zealand at the moment, and she is without power. So Margaret tonight's coming in via candlelight and a cell phone charger, and welcome. So thank you, Margaret. So I'm going to hand over to William. Everyone here knows William, but I'm still going to introduce him anyway. William, of course, is the Secretary of the Asia Pacific chapter of the IAFL. William is a Perth-based practitioner with 20 plus years experience, specialising in all areas of family law, particularly complex high net worth clients, difficult cases. He's the man to go to. So I'm going to hand over to William at this point to moderate the session. He has one of the speakers with him in person that you'll see, so that's Stephen tucked in the corner. And I'll leave it to you, William, to take it from here.
Thanks, Inga. So welcome to everyone, and before we get underway, really want to say thank you to Inga and the very hard-working members of her committee who work all through the year to put together this education program that we all enjoy. I know that committee works enormously hard, and the result of that hard work is, as I said, the education program that we all enjoy. So I think it's appropriate that we acknowledge that work that Inga and her committee do tirelessly on our behalf. Welcome also to the audience. We've had a terrific response to today's events. When I looked, I think over the weekend, we've already hit 47 registrations, coming from some 23 jurisdictions, spanning everywhere from Hungary, Israel, Kenya, Mexico, Switzerland, and beyond, and of course also throughout our own region, the Asia Pacific. So the topic or the registration and the breadth of where those registrations have come from tell us maybe we've hit a topic that's of at least some interest to a relatively large number of fellows. As Inga has said, we are in for an absolute treat. Inga and I had the real privilege during the course of last week to do some preparation sessions with the 4 members of the panel, and so we've had something of a preview of what they're going to share with us all now. And as I said, you've got 4 absolutely expert, thoroughly expert speakers, all of them very generously given up their perspectives with us today. Because we are going to find sufficient speaking time for 4 members of the panel, I'm not going to take you through each of their very extensive biographies. You do have available to you in the email that you received inviting you to register a little snapshot of each of their biographies. And just before we started, I have dropped into the chat the link to each of their 4 biographies if any of you want to get into that and raise those ones. But rest assured, we've got 4 leading experts in this area, all very generously sharing their thoughts and perspectives. As you mentioned, the topic today is cross-jurisdictional comparison on the preservation, use, or destruction of embryos in the event of a separation or divorce. Our 4 members of the panel: Margaret Casey, KC, a fellow from New Zealand; Stephen Page, who's sitting adjacent to me. Don't be confused, I'm not in Brisbane with Stephen. Stephen's happily for me in Perth this week attending a conference, and so has taken the opportunity to come in and present from my office. We also have Anil from India, who's also well known to the audience as one of the fellows, a very member of the Academy, and the 4th member of our panel is Sarah Williams, who is joining us from London and will be able to give us a perspective on some of these issues from outside of our region. The other three speakers bringing us perspectives, albeit different ones, but from within the region, and Sarah bringing us a perspective from beyond the region. Each of the speakers are going to broadly, just to give you some sense of a map and a framework, each of the speakers is going to very briefly say something about whether and to what extent there's some regulatory regime, legislation or otherwise in their jurisdiction. But for time constraints, don't expect war and peace on that question. It's going to be a binary yes or no, there is or there is not some regulatory regime. It just gives you some context as we come to some of the other matters we're going to discuss. The second question each of the speakers is going to address is really the headline one of the scenario where parties during the course of a relationship have created what is now some stored embryos. They then go through a separation and really then the contest as to what should happen with that stored material now that they're in the situation of having separated. And the third broad topic that each of the speakers is going to touch upon is to what extent is there some capacity to be ahead of this, prevention better than cure? Is it possible through the documentation done with the clinic or in some private agreement of prenuptial or otherwise, as between the parties to, again, turn their mind to some of these issues and to decide in advance what ought to happen if they find themselves in these circumstances. Each of the speakers is going to speak for somewhere between 10 and 15 minutes. At the 10-minute point, I'll gently let them know we're at 10, and if we're still going at 15, I'll more enthusiastically let them know we're at 15. Please be kind to the speakers. As I said, they're all enormously experienced. All of them, no doubt, could have, without any effort, spoken for the full hour, and so they've really been very gentle in allowing themselves to be compressed into that shorter time frame. If there are questions, we'd ask that they be held over to the end. If we've got some time at the end, then I know the speakers will be delighted to take those, but that will depend on how we're going with timing at the end, because we're conscious of our commitments to get you out the door and to allow you to either finish your day if you're on that in that sort of a time zone, or for people like Sarah who are just trying to start their day, either way you want to sort of wrap up reasonably on time. So we will try and do that. So with those brief introductory remarks, I might start with Margaret and hope that the candlelight lasts us the duration. Over to you, Margaret.
Kia ora koutou. I think I could start something new, you know, with this whole twilight, candlelight, ghostly thing. It's very flattering, particularly when you get to a certain age, and I'm rather liking the sort of the soft lit focus that I'm bringing to this. It's not particularly easy, so I'm doing this by torchlight. I have no power, and I probably will peel off everyone once I've done my little bit. I can't see what the timing is, William, so do please tell me when I'm approaching that 10-minute mark. All right, everyone, so let's start right at the bottom of the world and down under with this issue of regulating the treatment of embryos and what happens when couples separate. It's a thorny issue for most jurisdictions, how to deal with stored embryos and who can use them. It creates a moral dilemma, actually, for public policy across so many jurisdictions. The most common response, and New Zealand's current policy reflects this approach, is that when a couple create embryos intending to parent any resulting child, then the consent of both parents will always be required for any treatment. Absent that consent, a fertility clinic cannot use the embryos. So in New Zealand, contemporaneous mutual consent is required by fertility clinics at every stage of any IVF process. At the stage of transfer, when the embryos are frozen, stored, and if there is a dispute, then the embryos remain in storage until a decision is made by the couple or the approved storage period expires, at which time the embryos are destroyed. So in New Zealand at the moment, the storage period is 10 years, and beyond that, the storage life can only be extended with the approval of an ethics committee. And it is unlikely an ethics committee would agree to extend storage where there is a dispute with no sign that the parties are going to reach agreement. So at one level, this requirement for mutual consent presumes that the competing interests of potential parents should be given equal weight. It offers a clear default position. Nothing can happen unless both consent. And for many people, they think, well, that's fair enough. Each person has equally contributed to the creation of this embryo. It's much more egalitarian to require both to make decisions about what happens. It is gender neutral, and no one should be compelled to become a parent against his or her will, with all the financial and emotional consequences the creation of a child entails. But some writers say that the reality is that by requiring mutual consent, this system benefits the person who seeks to avoid procreation. By withholding consent to use, one party effectively vetoes the aspirations of the person seeking to use that embryo. Now, of course, we all agree it's undesirable to force someone into parenthood, but the question is, isn't it equally undesirable to end a person's only chance, perhaps, for genetic parenthood if those embryos are destroyed? And it is the cases of the last chance embryos that are most fraught and have the greatest impact on females. Because the biological reality is that for men, sperm freezing is relatively simple, accessible, and successful. Plus, men are able to produce sperm for longer than women are able to produce viable eggs. And for women trying to preserve their fertility, they will have a greater success with conceiving if they freeze an embryo than they will have if they freeze their eggs. So when some couples separate and they disagree about the disposition of embryos, one person in reality may lose their ability to control whether they become a genetic parent. And that makes these decisions particularly fraught and painful. In New Zealand, none of our cases have yet come to the court. There's been a couple of reports in the media about the dispute, some various disputes, but so far it is unlikely that we will ever make a decision in this jurisdiction to treat embryos as property to be assigned to one or other spouse on separation under our current property legislation. And even if those embryos are deemed to be property of, say, a wife, without a change in the fertility regulations that apply, I think it unlikely that clinics would want to work outside the terms of an earlier clinic consent in relation to use. But notwithstanding the lack of reported cases, these disputes are definitely simmering in this jurisdiction, because over the last 3 years I have provided advice on about 8 storage cases, all slightly different, 2 involving deceased spouse, all complicated, all frustrating, and all with limited remedial options available. I have formed the view that the reliance on the consent form isn't the right response tool for all of these scenarios. The stakes are too high for a default position that effectively says nothing can happen unless we both consent. So what might be the alternatives? An option often seen in the United States is for a pre-fertilization contract, a binding enforceable embryo disposition agreement between the parties, a bit like an advance directive. The advantages would be that this would be a much more informed approach in the process of working through agreements. Parties are really likely to think about all possible scenarios, like a promise, potentially. An agreement serves as a mechanism to ensure a commitment is acted upon. My experience with the fertility clinics and the consent form signing process, and I'm sure the other panelists will agree with me, is that there's often very little discussion and opportunity to think about options when parties are at the beginning of a fertility process and being presented with forms and asked to contemplate scenarios that just seem beyond them at this stage. My problem with the pre-fertility treatment agreement is that one size doesn't fit all, and as with our prenuptial property agreement, circumstances do change, and those agreements can no longer feel fair or be fair. And is it appropriate for such significant agreements to be contractually binding? When I was putting together these thoughts, I was doing some reading on this topic, and I came across a paper for anyone particularly interested in the New Zealand perspective by an academic at Canterbury University, Carolyn Mason. And she wrote an article in a bioethical journal in which she talked about another model. And she proposed engaging the court. In New Zealand, we have a specialist family court, so she's proposing the New Zealand Family Court would be the appropriate forum to resolve these issues. She says, and she argues, that it is only with a court approach that you would be able to balance the various interests that are at stake in embryo disputes. Because if the other models favour those who do not want to create children, they will then fail to take into account the interests of those who wish to have that child. And they fail to take, by applying the rules around consent, leaves no room to take into account relevant contextual information like, why is one of the parties refusing consent? Is there a potential manipulation to benefit from an overall property division? What are the reproductive alternatives for the party who is not able to access the embryos? What are the interests of any potential child? And one of the arguments she makes is that if it is possible by regulation to change the legal status, say, of the male from intended parent, which was his status when he created the embryo, to the status of donor, that might offer a solution to the concerns about a future financial burden for a child that he will never parent, because donors under our law and in most jurisdictions are never treated as a parent of the child created from their genetics. Advising clients in these cases is frustrating and fraught. They're not common, but I predict that we'll see more and more given the increasing numbers of couples accessing fertility treatment and the increasingly common practice of storing surplus embryos even if they have already had a child from that treatment.
That's 10 minutes.
That's 10, okay. Of course, those decisions should be made by those who created the embryos. But in New Zealand, and I don't know about in your jurisdiction, our separated couples are not always well behaved, and they struggle to balance each other's interests. Anger, grief, financial anxiety may all impact on the decision-making process, and the thought of creating a life or co-parenting a child with someone you are trying to distance yourself from will feel an impossible task. I do think a court pathway is a good pathway for some of these cases, and I think the option of changing status from parent to donor is a workable option. I'll finish with two final observations for you just to bear in mind if you come across one of these cases. They are an emotional rabbit hole. Lots of energy is expended on getting the right to access these embryos. And often the first point that people lose sight of is that it is an imperfect science, and the embryo transfer itself does never actually guarantees that there will be a baby. But my view is that often the real issue is about being able to make a choice whether or not you will choose to use that embryo as a single person or not. And in my experience, some of the women that I have worked with, having negotiated the right to decide about the embryo, they subsequently decide not to act on it. But being able to control that decision rather than having it removed from them as part of the end of the relationship becomes increasingly important. And I think I had another page, but it's gone, so I will finish there in my twilight. Thank you, everyone.
Thank you, Margaret. That was really very insightful. Obviously, bears out some lived experience from some of the cases that you've seen and some of the trends and observations you've seen over having been involved in a number of those cases, some of those common threads that are running through those that you've been involved with. We're now going to pass from Margaret to Sarah. Hopefully, Margaret's candlelight sustains her to be able to listen to what Sarah has to say, but if Margaret drops out, no one will think that she's upset or aggrieved by what Sarah said. It's not some form of tantrum throwing, it's just that the power's gone out. So, Sarah...
Well, given that I persuaded Sarah to join, the least I can do, Sarah, is to stay and listen. Thank you.
Thank you very much. Thank you, Margaret. Thank you, William. So the answer is, do we have a regulation and legislation? And the answer is yes, we do. The primary legislation that we have in relation to the storage and use of frozen embryos is under the Human Fertilisation and Embryology Act 1990. And that applies whether the would-be parents are married in a relationship. And it extends quite unusually to England, Wales, Scotland, and Northern Ireland, although post-Brexit there are slight differences between our position and Northern Ireland. And then in addition to that legislation, we have a regulatory body, which is the Human Embryology and Fertilisation Authority, which is set up in effect to inspect the fertility clinics, enforce the law and provide guidance to ensure they're complying with their legal obligations under the Code of Practice. And as Margaret has alluded to, there's huge emotion in creating these embryos. So there's obviously a huge emotion, usually at least on one party's part, when there's an issue regarding their continued storage and use. And likewise, we're seeing an increasing prevalence because there is that high success rate with frozen embryos. And here in England, we have a very extended storage term, up to 55 years. So family practitioners here will see it coming across their desk with increasing frequency. On storage periods, so in quite a contrast to New Zealand, it used to be 10 years here, but now it's been extended, as I say, to 55 years under a Health and Care Act in 2022. But that's subject to consent being renewed every 10 years. So it's important for practitioners to be aware of the various storage provisions in different jurisdictions. And to understand the issues arising on separation and divorce, you first need to understand, one, what is the legal status of the embryo in this jurisdiction? And in light of that status, what is the legal basis on which the frozen embryos can be stored and used in treatment? And then when can that consent be withdrawn? So we're looking at what the legal status of the embryo here is. It is not property. They're not chattels. The court cannot make any order in relation to them. They can't be divided or distributed by the court. They just don't have that jurisdiction as they would under the Matrimonial Causes Act or under Talata or under the Children Act. So that's I suppose, a very simple position. But it's important also that I highlight one slight exception to that. And this is an important case here called Yearworth, where the question for the court after sperm was damaged by a hospital was whether it could be conceived as property in the context of a negligence claim. And the court found that in that very specific context, yes, it could be. So that they taught it was property and the claimant could recover damages. But on the whole, they are not, the general principle is they are not property. So on what basis can they be frozen and stored and used in treatment? It is, as in New Zealand, consent, consent, consent. It's central to the ethical background and the legislative and regulatory framework. So if you take away nothing else from this jurisdiction, it's the long storage period and the fact that it relies on consent. The obtaining of consent here is not a tick box exercise. There's a duty on the clinics. It's taken very seriously that that consent is given freely. They have capacity to do that, and it's overseen by an authorised party. It must be in writing and legally valid. So it's not a cursory consent process. So understanding that, how do you resile from that consent in the, upon separation and divorce? Well, that consent can be withdrawn at any time up until the embryos are used, wherever that fits on that journey to separation or divorce. And when consent is withdrawn, notice of this withdrawal of consent must be given to every interested person. So if you are the party or you're advising the party withdrawing that consent, you need to make sure that the proper procedure is followed. And then that triggers the withdrawal of consent, will trigger a cooling off period, which is 12 months. And that allows the storage of that embryo to continue. It doesn't allow the use, but it allows the storage. And that allows the clinics, it allows the parties to see if they can reach a resolution between them as to the use of the embryo. So when a couple separate and one or both want to use the embryo either together or separately, we need to consider the status of their relationship and their genetic affiliation to that frozen embryo. We know the position of the mother is the one that has carried and given birth to the child, but who is the father or second legal parent is a much more complex issue. Where there's no genetic link between the father and the frozen embryo, so we have a scenario here, post-separation, if there's no genetic link, but they are married or in a civil partnership with the mother, he will be presumed to be the legal parent unless it can be shown that he does not consent to treatment. So that's really important. That's something to take away. But once, in scenario 2, if the father or second legal parent has no genetic link to the embryo and is not married to the mother or in a civil partnership, then the issue is whether or not some relevant parenthood criteria can be met. And they can both consent to parenthood if certain criteria are met before the embryo transfer or insemination to ensure that they're both recognised as the child's legal parent. But it's important for the client to remember that consent to legal parentage can be withdrawn at any stage prior to the implementation or embryo transfer, so that you can have the parties separating, you can have that consent continuing, whilst perhaps the finances are being resolved, there may be an extension of that goodwill, but that consent can be withdrawn at any stage. So what is the situation where the father has a genetic link to the embryo? You have to consider, is there another individual who can be considered a legal parent? Instead, If not, then the common law position is that the genetic father will be the legal father of any child born. So this can create a rather confused picture here. And fertility clinics are obliged under that regulatory code of practice to check a couple's relationship status when they are undergoing treatment. So as in New Zealand, at each stage, check that relationship status and check that consent. And if consent, and if one of them doesn't want to be treated as a legal parent, then they need to inform the clinic of the withdrawal of their consent. And then I'll just summarise quickly 3 cases of interest. In P&Q and RS, the court was asked to consider a declaration of parentage by a father and a cross-application of non-parentage by a mother in relation to children conceived following fertility treatment. They had a relationship at the time of the fertility treatment, but had subsequently separated. The father believed the forms they had signed made them both legal parents, but an audit revealed by the regulatory authority revealed that the form addressing consent had been incorrectly completed. The mother relied on that, changed the children's name without informing him, relying on his lack of parental status, and then he capitalised on that and sought to avoid liability for child maintenance. But the court held that errors on the forms were obvious and they could be corrected to reflect the original agreement and that they were both legal parents. And then another case, this is a big seminal case here in this jurisdiction, which deals with the issue of consent. It's Evans and Amicus Healthcare, 2004, where a mother, prospective mother, had her ovaries removed due to precancerous cells whilst they're in a relationship. Then they separated. The would-be father withdrew his consent to storage. She applied to prevent the destruction of the embryos and to proceed without his consent, but the court was completely against her, saying that her Article 8 rights were not violated, and so she couldn't use those embryos in treatment. And then the final quick case is BBIVF Hammersmith 2020, where unmarried partners had frozen embryos in storage. The mother forged the father's signature on the consent forms after separation, knowing full well he would not agree to implantation, and the embryo was implanted, a daughter was born. The father sued the clinic for failure to obtain his consent, and whilst the court found that the mother had been dishonest, the clinic had failed in its statutory duties. The father's claim failed. He failed to sue the clinic because it was against public policy for him to be able to recover the prospective financial liability of having a child. So that's...
Just letting you know that's 10 minutes.
Sorry, thank you. So where a former partner is considered a legal parent, upon the birth of the child, the only real routes to extinguish that parentage would be for the parent using those embryos to rely upon an adoption order or a parental order. But even if the parties agree they won't be registered on the child's birth certificate, for example, post-separation, and that neither will seek a declaration of parentage, those agreements are not enforceable and they would not prevent a child seeking a declaration of parentage under the Family Law Act. So practical points, I think, for practitioners to consider. Increasing area, do check the local jurisdiction. There's a lot of movement of embryos. If one party doesn't agree, the possibility of export from your jurisdiction and importing into another jurisdiction. Look at all the options, but be sure to take local advice. When you're first meeting the client, do ask about the existence of genetic frozen material. I think this is something that needs to be done as a matter of course now. Don't rely on the clients necessarily to bring it up. And do ask to see, if they do have it, do ask to see the actual consent forms from the clinic. Prenuptial agreements, they're not property in this jurisdiction. We rely upon consent. a provision in a prenup that provides for consent to continue post-separation is at odds with the statutory framework, which specifically requires informed ongoing consent. And I think that's it. I'll hand over back to you, William.
Thanks, Sarah. I confess when you said 55 years, I nearly fell off my chair. With that, I'm going to say thank you to Sarah for that contribution and hand over to Stephen. I'll just sort of point the camera in Stephen's direction so you have a solid view of Stephen.
Lucky you. And I've got the timekeeper just here, so I have to be very careful to stick to time. I think the number one message I want to give to everyone this afternoon, particularly practitioners in Australia, is that when you see a client for the first time on a family or property matter, you must ask whether they have genetic material in storage, because in Australia, sperm is property. There's no question about that. We've got a series of cases from New South Wales, particularly, also in Queensland, about widows taking their husband's sperm, and quite clearly the courts there, and also in South Australia and West Australia, said sperm is property. But the High Court has said that sperm is property, and so the Headland Maxinell damages case concerning the purchase of an IVF clinic, and the sperm was defective. But where we hadn't got to was whether embryos were property. And 1 in 17 children born currently in Australia and New Zealand are born through assisted reproductive treatment of some kind. And it's estimated 17% of those are born through non-traditional families, primarily single women, lesbian couples, and some gay couples through surrogacy. And when I've seen this arise in practice, there are two broad groups of clients who come in. They are husband and wife, where it's her genetic material and his genetic material in the embryo, and lesbian couples, where it's one of theirs and obviously a sperm donor. So quite distinct groups. Nevertheless, the issues remain, and I want to take up something that Sarah just said, which is having a checklist. Make sure that you have a checklist to ask, because if you don't ask, and because Australia now it's clear that embryos are property, and you haven't covered it off, in an order or by financial agreement, well, good luck. You may find yourself on the wrong end of the negligence claim, talking to your insurer. And we have had a series of cases in Australia regarding embryos. The first two are in Western Australia. The first of those turned on state legislation and the consent form. And the consent form said, well, if we split up, then they are to be disposed of. The embryos are to be disposed of. No surprise, the court came to the conclusion when the wife said, well, I want them disposed of. The husband said, I don't want to use them, but I want to donate them to science or another couple, order to dispose of them. The second case, and that's a case called G&G. The second case is that ironically known, aptly known as Piccolo, given the size of what it was dealing with. And that was a Western Australian case. And it was taken as given in that case without really any debate that embryos were not property. And the case again determined on consent forms, but curiously it wasn't Western Australian consent forms. The embryos were stored in Canada because the couple had undertaken surrogacy in Canada before. It may well be that the wife took objection to the husband using the embryos next time round because he had now partnered with a relative of birth. But she didn't have standing. Margaret, do you have power now? Wow, there we go. Marvellous. So she didn't have standing on that issue. So there's no, on the basis of an injunction under Section 114 of the Family Law Act, he was able to use. And in a practical sense, that has been difficult to do, be able to rely on, because first, you can't do consent orders before a registrar on an injunction. And if you've got a de facto case outside Western Australia, there's not the jurisdiction on that if it's not property. There were then two decisions in Queensland, one by Justice Bunn and one by Justice Hogan, that said embryos were property. There was an unreported decision from Victoria where the Federal Circuit Court judge declined to deal with embryos, saying that they weren't property, she didn't have jurisdiction. And in December, I got a judgment from Judge Dennick on a reported decision who refused to provide reasons, but she accepted the argument that the embryo was property. And there wasn't any dispute between the parties, but we wanted an order. But earlier this year, Justice Riethmiller, in a case called Lena and Lena, and for those of you who want the citation, it's 2024 FAMC 1F, this lovely citation we currently have in Australia, 135. And His Honour quickly came to the conclusion that the embryos in question were property, and the wife wanted to dispose of them herself. She originally wanted to use them, but the husband was opposed to that. And so his genetic material, her genetic material, then she wanted to dispose in her terms. The court found they were property, and well, she didn't get away with it. They had to be disposed of. So that then brings to what we can now do in Australia, which is you can bring a Section 79 application, a property settlement application. But one of the applications that might be brought in Australia is a Section 78, a declaration of property. The assumption is that an embryo is jointly owned property, but that may not be the case. Because I've certainly had a case where a lesbian couple, only one of them put the money in. She was the one who paid for all of this. She was the one who had the sole legal and equitable interest. And we subsequently, my client, through me, subsequently persuaded the IVF clinic, after the limitation period had expired as property settlement, that she was the sole owner. She was the only one who consented. No one had signed, they hadn't signed the forms correctly. I think the point that Sarah and Margaret had made. Forms used to be, typically in clinics in Australia, if you split up, do you go to court, do you destroy, do you donate, etc., or do we may have a decision made by them jointly. These days the clinics have got smart about it, and they're saying, if you split up, let us know. That's it. So someone else makes the decision about what happens with them. Just like my phone can come back up. It's locked itself, sorry. The issues of regulation of IVF, we are in an unfortunate position in Australia. Currently, we have 6 versions of laws dealing with regulation of IVF. By the end of this month, we'll have 7, and by this time next year, we'll have 8. So it's amazingly complex. It varies state by state. But Lena and the earlier Western Australia case of G&G partly turned on state IVF laws. So unfortunately, you need to know them. What I'm saying in practice is that if you've got a heterosexual couple, what the man will be concerned about if the wife wants to use the embryos, am I going to be dad? Am I going to have 18 years of child support? And most of the time the answer is simply no. But that simple answer of no is a very, very long letter. So it's what I've often found is if he can be persuaded, or his solicitors, and then therefore persuade him, that he is not going to be the father, he then consents to the wife being able to use them. And that is the most of the time the norm. In one case between a lesbian couple, there was one child had been born with the genetic material of my client and sperm donor, and there were still some embryos. They were in the midst of litigation concerning a relocation case. An agreement was reached that my client could use the embryos, but only after the court case was over, so we had a time limit of that, 18 months. Got her to check with her obstetrician that her fertility specialist said she'd still be okay to carry, she could. And what that would then mean is they could do a deal about the embryos and the relocation case could go on. Because what the other side feared was that if my client had another child, that'd be the balancing, or tipping the balance in favour of my client, weighing the scales. So they managed to do that. One of the more complex ones, Sarah was talking about export. The other one is, what if an order is proposed to be made about an embryo here, between the parties here, but the embryos are over there, somewhere in another jurisdiction. And I had that happen earlier this year with orders made in Singapore, but the embryos were stored in Australia. Could the Singapore order be enforced? This was in Queensland. The answer is yes. Would he be a parent? Would he be liable to pay child support or child maintenance? Because you've got to look at both. Because it's an international matter. Answer no, because he wasn't a parent. Very complex. But what happened, he'd opposed it all the way through, and then he said, well, actually, I'm okay for you to use because I'm not going to be able to get it. And they have resolved it. And that's probably the norm that happens. And the last couple of things Sarah alluded to, if you can't use it here, then consider whether you might export somewhere else. And you therefore have to look at the regulatory regime about export, who has to consent to export. And finally, because it's now property, embryos are property here, therefore they can be covered in binding financial agreement. They have been by some for a while, but I also concern that the concern that Sarah's raised, if it's not property, it can't be covered. But because it's quite clear that embryos are property, therefore we can have it in a pre.
Thanks, Stephen. Thank you. I think that now takes us to Neil to give us some perspectives of the position in India.
Thank you, William. Such illuminating and interesting perspectives within the jurisdictions which have been gone into. Now, I take you to India, where I think we are facing a different kind of scenario and issues relating to what I would call crypto-preserved embryos jurisprudence. In simple terms, law on frozen embryos. We do not have domestic issues, we have international issues on this proposition of frozen embryos. So we have Japanese, we have Israelis, we have Australians, we have American, we have English couples, both same sex, opposite sex, doing frozen embryo births with surrogates, which has expanded us into an arena of international laws pertaining to nationality, citizenship, parentage, control, care, custody, nationality. You have no idea how vast the issues have gone. We have authored 2 books on this. One is Surrogacy in India, A Law in the Making, and a Surrogacy in India Revisited. But this is all about frozen embryos. We silently started in 2005 when the Indian Council for Medical Research under the Ministry of Health and Family Welfare came out with guidelines which are known as the National Guidelines for Accreditation, Supervision and Regulation of Artificial Reproductive Technology Clinics in India. This went on, and the frozen embryo concept developed slowly over a period of time till until now that we have an Artificial Reproductive Technology Act of 2021. So in 15 years we have graduated into a law with defined parameters and very regulated machinery which is monitored by the government. We have over 2 lakh IVF clinics in the country. We are 3.28 million square kilometers, 1.3 billion in number, 29 states and 7 union territories, and a huge hub for frozen embryos, married and mixed with surrogacy though. But at the same time, these cryogenic jars with liquid nitrogen at 196 degrees minus frozen are lying in thousands all over the country, and hospitals do not know what to do with them. Now, before we address the issue, I want to go to the core of the matter. What is a frozen embryo? As I can understand from medical language and going into it is a developed or a developing organism after fertilization till the end of 56 days of fertilization. So the question which I have put to myself is it life? Is it future life? Is it an organism? Is it an asset? Is it a property? Has it got a ownership? And the next question, which will come in points of time, does an embryo have a right to life? We have a very vibrant concept of right to life under Article 21 of the Indian Constitution, which is available to all persons, not citizens. So every person has a right to life and personal liberty in accordance with law. Can a couple divorced, separated, same-sex, multi-sex say, I have a right to the embryo because it is my life, it is my contribution? Or conversely, can an embryo say, I have a right to live, I should not be used as research material? These are questions which have come up in our constitutional court, and they are going to be of international frames. We have already had a Japanese case, baby Manji Yamada, born in India to a Japanese couple, and when the child was born, they were divorced. The mother didn't want the child, so the father had to bring in his mother and file a constitutional petition in the Supreme Court of India to take custody of the child, because he could not have taken custody of a girl child. So this became a very complex issue, and the court did not know how to deal with it because there was no law in 2008. Then we have had gay Israeli couples going, coming, taking, and then there with fights in between and counterclaims. Then came John Bala's case, twins born, given Indian nationality, quarrel between the couple. Again, the court had to intervene and let them go, leaving it to them to determine their parentage and control and custody issues in Germany. Then came baby Emperor's case. A mother from the US, West Indian lady, brings her partner's sperm in a cryogenic jar to a city in India, hires a surrogate and gives birth, and wants to take the baby out. She has not contributed any genetic material. The Indian authorities refused to give her control and custody of the baby. Husband cannot fly in because he has aerophobia. See, imagine the jurisprudence which an embryo is taking us into. It's an unborn life, but look at the complexities it is projecting internationally. We have gone into the international frame because we have been a hub for reproductive medical tourism industry. We went on and on and on ahead till 2021 when things stopped. It is now meant only, this process is meant only for infertile Indian couples, men and women married for a period of more than 5 years. It's a retrograde law, it has reversed a lot of things. But these are grey questions in grey areas which were there. Now, as far as the 2005 guidelines are concerned, they were very clear on embryo preservation rules, consents for freezing embryos, use of embryos for research after 5 years with consent of both parents, and a total control on any sort of misuse on the embryo. As far as consents and conditions were concerned, it was all joint. When we come to the Surrogacy Regulation Act 2021, that is a part. But the Assisted Reproductive Technology Regulation Act 2021 is a very wholesome legislation. Now, in section 21, it very clearly talks of a storage period of 10 years, following the pattern of some countries. And the consent in terms of storage is to be given by both the parents. And section 28 further prescribes that the stored embryos will be preserved by a clinic the artificial reproductive technology clinic, which have to be registered with the authorities, and they will not be allowed to be used for any other purposes except by the couple for 10 years, after which they will be donated for research or to research organizations for research purposes with the consent of the commissioning couple. And thereafter, the Act also prescribes an agreement for consent for the freezing of the embryos, and in that both parties are signatories. Without the consent of both, the embryo cannot be used in any form, nor it can be shared, nor it can be donated, nor can it be destroyed or in any way got to put to any use. Now the question which is now coming up, and there was a recent write-up saying potential lives await their fate across IVF hospitals in India. The issue is the hospitals want to know what do they do with crypto-preserved embryos or frozen embryos which are not claimed, which are not being wanted by parties. What do they do with them? Nobody wants to destroy them. Nobody wants to use them for research. Though ideally speaking, stem cell research is the next generation medical advancement of technology, where cells from embryos will be used for implanting in designer children or curing diseases or whatnot. It's a very dangerous area. It is healthy also, but it God knows where it will take. Now the question.
Just to let you know, that's 10 minutes.
Yeah, just 2 minutes more. Now the question is, in our country, the family court would not be equipped to decide on issues concerning rights on the embryo, because it is not a born child. Custody, abduction issues will come when the child is born. So the only remedy for claiming the embryos would be a constitutional court. There are a lot of parents abroad who are not able to reclaim their embryos because surrogacy is no longer allowed. So if there is one parent or both parents who want to claim back their frozen embryo, they have to go to a constitutional court to reclaim the embryo. There is no other way. And that puts me to an end, and I will be very happy to take questions with whatever inputs I can share. Thank you very much.
Thank you, Anil. That was really terrific insight that you were giving us there. I think we do have just a couple of minutes. I'm conscious we're pretty close to coming up to time. So I wonder if there's anyone in the audience that wanted to take advantage of the expert panel that we've got. I think Margaret's battery has passed out and we might have lost Margaret. So please, no questions for Margaret, but I know Sarah and Anil and Stephen beside me are all willing to take questions. Perhaps maybe
Margaret's still with us, William. She's just showing up as me. She's come in on my link, so she is there. She's got power.
Okay, all right. So Margaret's fair game, and Sarah's just putting up her hand. So
I wonder also whether it's not worth raising. Obviously, we've dealt with is an embryo property or is it not property? And it's worth raising, perhaps, although none of us are from Alabama, that the recent Supreme Court decision there where a frozen embryo was treated as human life. So this concept of fetal parenthood. So it's very much a question of checking your local jurisdiction as to the status.
A couple of members registered from the US, although I don't think any of them are from Alabama. And US, obviously, very much the state-by-state proposition. But Sarah, I think your contention of get local advice supplies.
I saw that Stephanie Brickman was there from South Carolina as the chair of the ABA AOT. I was delighted to see you there. Yeah, that decision was just crazy, and it had the effect of immediately stopping IVF in Alabama and the past forward to allow it to occur.
Yeah.
I have one. Sorry.
Sorry, just on that point, Neil, back in 2012, we had a judgment in Brisbane, which said that it was about when was a child conceived, and so we were concerned about fertilisation, whether it was fertilisation or it was pregnancy, because if it was fertilisation, then my client, the intended parents could never obtain a surrogacy parentage order, because the surrogacy arrangement had to be signed before the child was conceived. And the court was persuaded, its first case in the world, that conception was the act of pregnancy.
And Neil, I know you had a comment there.
Yeah, I have been looking at this for quite some time. The Hague is already looking at a convention on surrogacy. And frozen embryos, how to deal with them is a core issue in that proposition. So how would frozen embryos be dealt with if they are exported abroad on application of laws and some kind of arrangement between countries is probably going to be a futuristic litigation area after about 25 years. Because the restrictions on frozen embryos being liberal in some and vast in some, people may be shifting jurisdictions to have beneficial laws, like the US.
Well, I've just done that recently in a case where embryos were created, but the man died, and his wife wanted to be able to use, but I came to the clear position that use was extremely difficult, expensive in terms of court proceedings, etc. to go in Queensland. So it was an export overseas, where it should be able to use. And her use was supported, the posthumous use was supported by members of his family. It's just when he went through the procedures under there's a bill just passed in Queensland last week. If and when that came to it came to force, or under the current regulatory regime, was just too hard. So export was the key. The very point that Sarah made before.
Sarah, I wonder if I can, to be fair, it's a question somewhat without notice, but Stephen's point that in Australia the courts have gone down the pathway of seeing it as property and therefore susceptible to the court making the property order, the sort of scenario that many of the people in this court will be involved with sort of internationally mobile families who live in, over the course of their marriage, a number of jurisdictions. So if we've got a scenario, say, where the material's being created and is still being stored in your jurisdiction, and later on they come to Australia and they end up separating in Australia, and one of them happens to Stephen, and Stephen very quickly gets an Australian order saying property, will that foreign order have any status, any recognition back in your jurisdiction where the clinic is and where the material is?
Thanks for stitching me up.
I just throwing Stephen under the bus here.
Absolutely under the bus. If I do that, check with Sarah first.
Yeah, it's a really interesting question, isn't it? Because you know, as Anil has said, you can imagine these global clients moving between beneficial jurisdictions, so that maybe they go to where that embryo is stored, so that they can rely on it as being property if it suits their agenda.
But that's the very scenario that they had in the Singapore case, and they held off making on orders. They had draft orders and said, "Oh, we draft orders, but both sides want to check out what his status is in Queensland, whether he's going to be a parent, whether he's got liability for child maintenance and child support, and can he, for example, be registered in Queensland." And of course, it could be registered, and I persuaded them that he wouldn't be a parent, he wouldn't be liable to pay child support, child maintenance, and therefore it was sweetness and light, sunshine and roses.
So I have seen it.
That is the big concern.
So Sarah, I have seen it shift. I've seen it shift from Nepal, Thailand, and then Ukraine. And Ukraine, after the war, there were no claimants because you couldn't reach them. They were in underground bunkers, thousands of them. The parents couldn't claim them. So what happened, I don't know. But it's a very interesting question. People shift to cheap jurisdictions for various reasons.
At the beginning of the war in 2022, 2022, many of those embryos were actually exported surreptitiously out of Ukraine to other countries such as Albania, Czech Republic, Cyprus, etc. So, and because they were doing that for survival, because the alternative was that they might get bombed and then lost forever, or the power might go like the US and lost forever.
See, in India, the US Embassy doesn't let you out till you do a genetic test. You have to match the DNA, otherwise it's not yours.
All right, I'm conscious we're probably just coming towards the sort of 1 hour time point. I'd give the invitation again if there's anyone in the audience that wanted to take advantage of the very expert panel.
I expected William to ask something, but William is silently noting down everything.
I was just asking Sarah difficult questions. Maybe one other question, which I think Stephen sometimes or somewhat touched on, is that idea of is sometimes child support or child maintenance one of the real issues that operating in the background. It might not, in the face of the dispute, nominally be the contentious thing, but Sarah, is that sort of, I know Stephen's expressed a view on that from his experience. Is that something you've encountered? As sort of
Yes,
issue?
yeah, definitely. It's a real concern, yeah. And that's behind their sort of hesitation to, otherwise they would consent to the continued use, yeah.
And Neil, is that something that operates in India as one of the factors in those disputes? The potential liability of the father to maintenance or child support as well as
You see, we haven't gone that far domestically. The rage is on an international platform, because I think anybody who preserves an embryo is with a conscious intention of both parents contributing equally. There is no two ways about it. You have a lot of postponing parenthood, working couples postponing paternity, but then ultimately bottom end there is no real dispute on division. So it's our baby. It's not your baby or my baby. So this is not yet, or maybe it hasn't opened up. It's going on. It's silent. It hasn't gone to court.
And it hasn't surfaced in the domestic cases.
Absolutely.
Explicitly, yes.
Maybe it's too private. It's too personal. It's not exploded. And if it goes before a court in a conventional way, they'll say, what do we do with it? What do we do? What do we do? Do you want it or you don't want it?
Yeah.
But William, that's the point. That's the whole point of actually allowing someone to change their status from intended parent to one of donor.
Yes.
And if everyone agreed to that, there would be no financial consequences.
What I was going to say, Margaret, was this: you have to be very careful about doing that, because from the clinical point of view, if the clinic requires counselling and consent from the donor, and the man in question, because typically it's a man, says that they won't take part in counselling, therefore you cannot get treatment, you can't get to use. So you go through all the court process, but you won't get to use. So you've got to be very careful in dealing with the clinic. Some clinics are happy to say, yes, well, because he was an intended parent before, we still have that status. They don't talk about what we would call donor, but if they form the view that he's a donor, then they won't treat. And in my case that was decided last year, we are having to move the embryo from that clinic to another clinic, because the clinic said he's a donor and therefore we won't treat because he won't take part in counselling.
There is another issue which has come up in India in one case I dealt with. Child abduction of a frozen embryo born to a gay couple. Who's the parent? Who gets custody? Whether English law, whether Italian law or Indian law will apply. It was very complex. Who's the parent?
I think the model that Margaret was talking about from that academic paper which Margaret referenced, that was, as I heard Margaret say, there was a layer there where there was provision for court involvement, recognising the complexity of the situation you're dealing with.
It's a very grey area. It is not yet developed.
For having the avenue open of the court being able to referee is to acknowledge that potential complexity. Is that a fair summary of what you were saying earlier, Margaret? In that model that you were sort of referencing from that academic paper?
Yeah, and it brings in a human element as well to understand the reasons.
And also, I think it is the only model that talks about child and puts a lens, you know, a focus on what would it be like to be a child conceived reluctantly on the part of one, or, you know, not at all. And so it would allow the balancing of that interest. And how would you address that for any child born? And what would the practice would be? And then, you know, there could be conditions around, well, there would have to be particular counselling for this child and that parent to assist them to explain the child's birth story. I mean, you could do lots with a model like that. Just lots. You build a whole lot of things.
We might, with Margaret's permission, circulate in the material that we circulate to the others the reference to that particular paper that Margaret has cited, and any of the other material that the others have mentioned during the course of the session. I think there being no further questions that have come from the audience, I'll be in trouble with Inga if I don't move to winding this up somewhat on time. You can see from the interaction there that we've got a really interesting issue and lots of different perspectives on an interesting issue. As someone in the audience, I certainly feel that I've benefited from a really expert panel who's brought plainly a lot of thought, a lot of expertise to today's discussion, and if we can show them in our usual way some level of appreciation for what they have put forward today. And John is sharing with us fascinating discussion. I'm sure that's the thought of a number of others in the audience. So those of you who are people who speak on these things know that to appear effortless for 10 or 15 minutes, there's actually behind the scenes an enormous amount of work and thought and preparation. So those people have worked incredibly hard, and we're really the beneficiaries of that. So thank you, those members of the panel.
And William, I want to thank you and Inger for organizing this marvelous session on such an insightful topic, which is so motivating and which has been so invigorating, and it has triggered off such a new thought process. And hats off and congratulations to both of you for putting this platform together and then following it up persuasively, doing demo sessions, fixing the questions, but not fixing the answers. 2 cheers for that.
Thank you, Adil. That's very generous, very generous. And with that, I'm going to hand back to Inga to bring us to a conclusion. And everyone has another drink.
And I'm still jealous that you've got Margaret River wine and I've just had tea. Thank you. Thanks, William. Really appreciated. Great job of moderating. You cracked that whip brilliantly. I didn't need to sort of remind anyone about that, so thank you. Thank you, William, Stephen, Sarah, Anil, and Margaret, aka the other Inga Blackford on your screen. She's my doppelganger tonight. I'm going to let everyone get away, but very briefly again, thank you to all of you. You've just been marvellous. Really, really interesting topic. Just a wee shout out for next month's session. AP Hour will be the 14th of October. Again, it's a Monday night at 8 o'clock UTC, and we're doing a presentation on international relocation of children. So if that's something that takes your interest, please sign up and join us. We would love to see you.
I am the new secretary of the Child Relocation Committee.
The recording has stopped.
And Anel, we expect to see you there. We would really appreciate it. And because it's Māori Language Week here in New Zealand, kia ora koutou katoa, everyone. Thank you.
Thanks a
Good
lot.
evening.
Thank you very much.
Thank you.
Thanks very much, all. Bye.
Bye.
Bye. Yeah.
See you, everyone.
Good morning. I just got a